This is a rebroadcast of a very important live stream from 22 September 2016, about a month ago. We have two extraordinary guests, Catherine Frompovich and Larry B. Kraft. They'll be talking about the CDC infectious disease regulation. The comment period ends on October 14th. It's urgent that you go to tinyurl.com/informed consent protection. Take action now and listen to these extraordinary guests. Thank you.
I'm the medical director of the Natural Solutions Foundation. We are dedicated to the very simple proposition that you own your body. No government owns it, no corporation owns it, no fused entity, no fascist fused entity of corporate state owns your body. And if you want clean, unadulterated food or air that has not been sullied with poisons or non-GMO products and foods in your life, or if you want to be vaccine or drug free, if you want to be free of radiation, zapping your DNA, then you have that right. It's called health freedom, your first and most fundamental right, the right to determine what happens to your body. And we are located at many websites, but our principal website is www.drrima, R-I-M-A, truthreports.com. It's all about truth, and it's all about empowerment to make the choices that you want for your life and your body. With me, my co-host and my co-trustee of the Natural Solutions Foundation, Ralph Fusatola, JD, a longtime vigorous attorney fighting for truth, fighting for freedom, fighting for our right to access the products and the information that we wish to use in our own health strategies. We're talking about freedom, and we're talking about a lawyer who fights vigorously for that freedom. Hello, Ralph.
Hello, Dr. Rima. Thank you so much for that kind introduction. Let me say to you, and of course, we have two extraordinary guests, but we also have a presence which is both present and not present. If you're watching the live stream, you see, of course, Dr. Rima and two other individuals who will be on the show, and then on the other side of the screen, you'll see an image of Dr. Rima, myself, and General Burt. And under it says Natural Solutions Foundation. It has our logo, and it is a group photo of the three trustees. I am so happy to report we are three trustees. Um, you know,
a couple
and
of weeks ago, a couple of weeks ago, on September 1st, when General Burt was admitted on an emergency basis to a hospital in the United States, where we had come for natural treatment, not for allopathic treatment, it looked very much touch and go whether we would indeed be three trustees or whether we would be two trustees, one of whom had been married to the third deceased trustee. But he didn't decease. He did not cease to be, and he has made what is considered here in the hospital, where every single physician involved in the case told me to expect him to die. Uh, Now, we all die, but they meant immediately. Um, it has been acknowledged that his turnaround has been absolutely, simply stunning and unexpected and unbelievable. And the way that turnaround has happened, hold on to your hats, fasten your intellectual seatbelts, and hang on for a really tough ride, has been with, are you ready? Nutrition. We fed his mitochondria. We supported his kidneys. He had gone into renal failure from septic shock. We simply gave his body the things that he needs to heal. They're called vitamins, minerals, cofactors, essential fatty acids, and other nutritional factors. And this was an astonishing event to all of the involved doctors and nurses, and I consider that to be jubilant for General Burt and tragic for the rest of us. How very stunningly sad that the metabolic miracle available to General Burt by crushing up pills or opening capsules of widely available high quality, high potency organic supplements and probiotics. That miracle is unavailable to most of the people who are afflicted with Western medicine. How very, very tragic.
Dr.
Meanwhile,
Rima, there's one more thing that made a big difference with General Burt, and that
yeah,
was you. You're of course broadcasting right now from the hospital. You've been
yeah,
there for, I guess, 20 days now.
21
It
days.
is the beginning of the autumn. The equinox is upon us, and yes, it's been 21 days. But you did something that was really important. You were there to say no, to say I do not consent. I do not give my informed consent when Bert could not say it. And
Exactly.
so important, and
And
really the gist of
I
today's
turned
program.
into I turned into a dragon, hissing with my claws out, my wings extended, and my tail lashing, saying, "Sss, sss, no, sss, sss, no. Why? Why do you want to do that? That doesn't make any sense to me." Sss, sss, and guarding my treasure. Now, every single person in a hospital, ideally, needs to have a guardian dragon. True, I have medical knowledge to go with me, but to make me more dragon like and fuel the fire coming out of my mouth. But all it takes is common sense saying, why? Why are you doing that? They had him scheduled for a tracheotomy, that's putting the airway at the base of the throat, when he had been breathing on his own for 48 hours. And I said, why? Why are you planning on taking him to the emergency room? Well, he's been on a breathing tube. He's been intubated for 20 days. And we have a policy that he has to have a trach after 2 weeks. I said, why? And they said, well, we have a policy. And I said, uh-huh, why? And no, you're not taking him to the surgical suite to put a trach in because he's breathing on his own. Duh. I said it very nicely because you have to in this kind of situation. But the point is, there I was with my tail swishing back and forth and my claws extended and fire coming out of my nostrils, saying, no, you have that right, folks. It's your body. It's your child's body. It's your loved one's body. Now, in terms of vaccines, I wrote on every form that I signed, whether it had anything to do with vaccines or not. All vaccines refused. And then I initialed it and signed the form. And they got sort of wild and they said, oh no, don't change the form, it's a legal document. I said, that's right, it's a legal document when I make modifications and initial them, and if you don't believe that, call legal. And they all backed down because they knew I was right. You can't make any changes to that document, then it's not a legal document that I can sign. Now,
Dr. Rima,
you
isn't
have
that
that right.
interesting? Does that mean that the legal department in the hospital even has more power than, say, the dietary department?
Ooh, that's hard to imagine. Um, my point is that we have these rights. The CDC at the moment, and we'll be talking about that with our wonderful guests. I'm so pleased to have them on, and I'm so pleased to have them together. Catherine Frompovich and Larry B. Kraft, two of my very favorite, intelligent, activist commentators and thinkers on matters of health freedom. Um, and we are facing a new level of medical tyranny from the CDC. We have about a month to bash it down by the strength of our numbers, saying the three most important words that an activist can utter. And those words are, don't you dare. And we have to say that to the CDC in our millions. And we'll be talking about what it is that the CDC is doing and why they are doing it and how it affects you. How it affects you, my friends, if we do not succeed in smashing this latest atrocity of a violation of health freedom down. How it affects you is cataclysmically because you become pharmaceutical chattel property to the state. Yes, so do your children. So, with that said, let me tell you that General Bert's breathing tube has been removed without a tracheotomy. Uh, Tracheostomy, I'm sorry, an opening in the trachea, and that today, the second of his three chest tubes draining fluid from his previously collapsed and fluid drenched lungs has been removed. Possibly the third will be later today. That General Burt was seen by physical therapy and actually supported himself sitting upright on the side of the bed for 5 minutes, which in a guy who's been bedridden now for quite some time is astonishing. And although he sounds very much like this, because of the damage to his throat, which will heal, he's talking and he's laughing and he's making jokes and he's confounding the people who expected him dead. Um, Everybody needs a dragon, and I am happy to be the dragon for our third trustee. You need to be the dragon for somebody you love when they're in the clutches of allopathic medicine. And the only time you should be in the clutches of allopathic medicine is in an emergency situation or a surgical situation. Other than that, why would you do that? So, with no further ado, let us move to the discussion of the newest round of medical tyranny and atrocity and government um, reinstitution of the institution of slavery.
Yes, Dr. Rima. And in fact, to give our two guests an opportunity to take a look at it, I know Catherine has written about this regulation. Larry has been on trial and doing lawyerly things, and so he may need a little bit of background to catch up with us on what's been going on with the CDC. And so I thought if if the guests would mind, not mind, I would basically read about 5 or 6 paragraphs that will set the tone. It actually has quotations from the regs, and I know Larry always wants us to look at the actual words, and that's important. I want you to start with our comment, and this commentary I'm about to read was submitted to the CDC as part of the requirement that the government has of of receiving the public's comments before making new regulations. And so, in an audacious violation of national and international law, the Centers for Disease Control, the CDC, a part of the Health and Human Services Department of the United States government, proposes the adoption of a regulation giving it power to quarantine and force treatment, vaccination, for certain unspecified quarantinable diseases. The proposed regulation brings medical tyranny to a new level of danger by specifically overriding any and all informed consent rights, despite the well established legal right to informed consent. The regulation is being proposed, as Larry knows, under the Administrative Procedures Act. The official summary of of this regulation sums it up, and it says that it is amending through this notice of proposed rulemaking. The CDC is amending its domestic interstate I draw your attention, Larry, to that interesting structure. Its domestic, interstate and foreign quarantine regulations to best protect the public health of the United States. By the way, that's not of the people of the United States, All right. Anyway, these amendments that goes on are being proposed to aid public health response to outbreaks of communicable diseases, such as the largest recorded outbreak of the Ebola virus in history. That was in Africa, folks. The recent outbreak of MERS in South Korea, and repeated outbreaks and responses to measles in the United States. Notice MERS and Ebola, two really deadly diseases, being equated with measles. Anyway, and we go on.
And let me interject. This is not in the regulation, but measles is a trivial viral disease in people who are not immunocompromised or starving, which is necessary to tune and tone the immune system. It's there for a reason. People who have actually had measles in childhood have less cancer in their middle life. They have a variety of other immune competence, healthy statuses instead of a variety of immune incompetence diseases. The measles virus seems to be a training experience for the immune system of human beings. Go ahead.
Right, part of the microbiome. And it goes on and it says in this introduction to the red, um, as well as the ongoing threat of other new or re emerging communicable diseases. Re emerging, those are all the diseases that people are spreading through vaccination. Anyway, um, affecting human health in the United States and interstate. Again, Larry, that interesting combination of words. I go on, what diseases are included? We must ask what diseases CDC has in mind. Measles, a non quarantinable and trivial disease, is mentioned 186 times in this regulation and introduction. Ebola is mentioned 330 times. Influenza, another non quarantinable disease, is mentioned 26 times. We're going down. And Zika, interestingly enough, is not mentioned at all. In context, generally mild, self limiting diseases like measles are irresponsibly and irrationally equated to deadly diseases such as Ebola. The regulation permits the CDC to include any communicable disease. A close reading of the proposed regulation shows the word consent is mentioned 12 times, always in the context of denying the individual right to consent. Sections 78.18 and 71.40 are two specific sections in which this occurs. And the phrase, these two sections are about entering into agreements. The CDC will allow us to enter into agreements with it. Well, that's what happens when you either do or do not assert your informed consent rights. It's all about agreement. Now, what does it say? Well,
Ralph, I'm off.
Hello.
Hello,
Hello.
Ralph.
yeah, oh, I'm
Ralph,
sorry. Excuse me.
this is Catherine. Something happened. We went dead.
Yes, you said,
Sorry about
what did
that.
it say? And then we lost you. Did your finger slip off the
My
button
finger may
that
have
you
slipped
have to?
off the magic button.
Okay.
Yep.
So
Sorry,
you
folks.
said, so you said, what did it say? And then we waited in
Ah,
anticipation to find out what it said.
well,
Please tell
what
us.
it says is that the CDC may enter into an agreement with an individual. Remember, informed consent is actually about agreeing, right? Upon such terms as the CDC considers to be reasonably necessary. This is, as Larry would say, I guess, a contract of adhesion. One side writes it, the other side either says yes or no. But in this case, may be reasonably necessary, indicating that the individual consents to any of the public health measures authorized by this part, including quarantine, isolation, conditional release, medical examination, hospitalization, vaccination, and treatment. And then it goes on and it says, provided that the individual's consent shall not be considered as a prerequisite to the exercise of any authority under this part. Very clear. There is no language in the proposed regulation that actually safeguards the right to informed consent. And then I go on in this particular article that we submitted to the CDC to quote from the Nuremberg Code and the UNESCO Universal Bioethics Declaration, to which the U.S. is a signatory. It's very clear that this is a violation of informed consent. And so what we've done is we've set up one of our action items, web form action items, so that people can tell the decision makers, their representatives at state and federal level, CDC, FDA, the usual gang of suspects, that they do not consent. I do not consent. And I want my legislators to adopt laws that will protect my right to informed consent. And you can find that at tinyurl.com, informed consent protection. That's on the screen, of course. tinyurl.com, informed consent protection. And that's the background, folks. That's where we start from. And we have a brilliant investigative journalist, an eminent attorney at law. Indeed, some of us have called Larry B. Kraft the dean of the Patriot lawyers. And we want to sit back and listen and understand. Larry, do you want to start with any comments you have on this whole question of domestic, interstate, and foreign?
Yeah, Ralph, I think there's an interesting problem that we have here with these new regulations that you've been discussing during the course of this program. Last week, I came home late at night, reading my email, and I saw all this stuff talking about that regulation. Read some websites that were discussing this particular problem, and then I started a brief examination of those regulations. And I think that we have a real problem here from our viewpoint about it involves one of perception, and the only way that you can get down to understanding the reach and scope of CDC and anything at the federal level dealing with health matters, we need to go back into history. First and foremost, a number of courts have said, and this was brought up before Obamacare was enacted into law, but there are a number of courts that have said, the direct control of medicine, the practice of medicine by the federal government is outside the scope of its powers. And indeed that is the case because the powers of Congress are outlined in Article 1, Section 8 of the United States Constitution. And there's nothing there about regulating the practice of medicine. So that's one field that must be understood when you try to understand the reach and scope of all of these laws regarding vaccination, the proper role and purpose and function and jurisdiction of the CDC. Now, let me go back a little bit in time, and I can't speak with authority on this. The only thing I can do is inform you that I have spent a tremendous amount of time dealing with, what is the subject matter jurisdiction of federal agencies? What is the reach and scope of, federal legislation? What role does a federal agency have in enforcing federal laws? If you go back and take a look at the old history, the way that Uncle Sam gets any authority over the control of diseases happened long ago at the ports of entry. You would have people coming from other countries, and they may very well be coming into this country with some type of communicable disease. They may need medical treatment, or they might be crazy. And, crazy is one of the reasons, seeing all these crazy folks that are wanting to get into this country is one of the reasons why St. Elizabeth Hospital in Washington, D.C. was first established. But, you have a real problem with foreigners, aliens coming to this country wanting to either visit or become citizens or become residents, the communicable diseases they may be carrying. So there has been historically a background for the development of these federal agencies that deal with, communicable diseases like the CDC. Now, with that background in mind, last week when I started looking at those regulations, I saw that, they're talking about reaching to the fullest extent of the interstate commerce power of Congress. Well, I really do think that you need to consider what is going on at the CDC from this viewpoint. That historical background showing that Uncle Sam's role regarding communicable diseases has its origins from in people entering this country, and I would suggest that that is still the case, that the parties that they could subject to, what we're talking about in this program, injecting them with vaccines because they got communicable diseases, I would suggest to you that the real parties that are subject to all that are not going to be American citizens, but are going to be foreigners. And hence the reason, that you'll find in a lot of the regulations and probably in the statutes relating to this, they're referring to the parties that are the human beings that would be subject to it as individuals. Now, on the point of individuals, I just want to make one little comment. I fell out of the chair. You remember years ago when there was going to be a 1 million-man march in Los Angeles of the Mexicans to protest, the immigration policy here in the United States? It must have been about 10 or more years ago. Do you remember that, Ralph?
Yeah, I remember it.
Right.
Okay. Now, I happened to be watching one of the talking head shows on Sunday morning on that occasion, and Ted Kennedy was being interviewed. And, I was astonished at his knowledge of the law. Of course, he has a legal background. But he referred to all of the million, what were probably all illegal aliens, 1 million of them or more, in downtown Los Angeles. He referred to them as individuals. And, there's a distinct difference. I think he was absolutely correct, and he knows what the term individual means. In this context dealing with CTC, I think that an individual is not an American citizen. So how about that for
Oh, so you think that this entire regulation is really aimed at foreign nationals?
So it's controlling the ports of entry.
Well, yeah. If you sat down and this is where it's so blooming important to when I get involved in any field of law, I want to watch its historical development from the first time that like for some of this interstate commerce stuff. I go back to the original laws and follow it forward. If you can get regulations, that explain it, that's also helpful. But if you follow the development of a field of law, you can really see the parties to whom it applies. However, if you don't do that and you only take a look at current legal materials like statutes and regulations, you're missing the limited purpose for a law that manifests itself when you're dealing with the older materials.
Well, now, if CDC manages to promulgate this regulation and it becomes a final regulation, which, folks, has the impact and the strength of law. So a regulation is not a suggestion. It has the strength of law. If that happens, and the CDC somehow, without making it explicit, intended this to be non-U.S. citizens, and I actually have trouble believing that that's what they meant, but they didn't put it in there, would they then have the right, as this regulation is worded, to apply it to U.S. citizens in the U.S. as well?
You're bringing up regulations now. I haven't had, I had to listen to liars all week last week in court. So, I'm kind of new to, this particular issue that's come up. It came up when I was rather occupied, and I'm still dealing with the consequences of all that.
Well, Catherine has delved into this issue, and I think it's time to hear from her and her perspective. She's one of the people who really raised the alarm that led us to doing what we're doing. Go ahead.
And let me say,
Thank you very much for inviting me on. I appreciate it. But first, I would like to say I am so pleased to hear the good news about Bert. And
Thank you.
I think it is an honest answer to prayer from many people, especially me. I pray for him and for you, Rima, twice a day. And
Thank you.
I am a person who believes in higher consciousness and raising the bar to higher consciousness. Listening to what everybody had said, I think I'm going to bring a different spin on my interpretation of what is possibly going on. First of all, I am of jaundiced eye and opinion enough to think that this could possibly be a sleeping something or other, some sort of a Trojan horse. And I'll tell you why. In reading through that proposed mammoth rule, the CDC has deliberately gone about redefining the definition of what an ill person would be. And I'd like to read them off because in the previous sequestration or whatever they wanted to do with regard to communicable diseases, it was the Ebolas, the serious SARS disease, and things like that. Now they're wiggling, as Ralph said, the measles to equate with that kind of horrible disease, which they are not. I mean, I had measles as a child, and when I had measles, every kid on the block had measles, and we all lived through them, and nobody died. This is all, in my opinion, a fear campaign that's being promulgated on everybody for some sort of reason that we probably all know. But here is what I would like your listening audience and us to discuss in view of what has been discussed previously. The reclassification of what an ill person is. Now, Dr. Rima, being an MD, this should ring a bell for you. Fever,
Okay.
100.4, 100.4 Fahrenheit, or 38 degrees Celsius or greater. That's what fever is defined as now. Skin rash, multiple red bumps, spots, blisters filled with fluid or pus. Difficulty breathing, gasping for air, can't catch breath, breathing too fast and shallow, persistent cough, coughs enough to catch the attention of a crew member. Now, this is interesting. They are sort of empowering pilots, stewardesses, crew members on ships, even maybe bus drivers. If they think that, you're coughing too much, they can report you to have somebody come and to take you into a quarantine. Decreased consciousness or confusion, bruising or bleeding, persistent diarrhea, persistent vomiting, headache with stiff neck, which is probably they're looking for somebody with meningitis or something like that. Now, it's very interesting that they have redefined everybody who they're going to say is able to be classified as a sick person. Well, children who have asthma, what are they going to do with them? Are they going to be
Oh,
all
very
right?
simple. They're going to vaccinate them. These are such broad categories, and they occur in so many things that have nothing to do with bacterial, viral, or other diseases that it's it's astonishing, and it empowers not only crew members, pilots, bus drivers. It empowers basically everybody, not only to be doing the Ashcroft see something, say something spy dance, but to be evaluating everybody's health all the time. Oh my God, that kid over there coughed. Call the CDC guys.
Can
What
I give you,
craziness.
all right, and can I give you something else that's very interesting from the text that rang a bell for me? There's a thing that they're calling pre-communicable stage. Pre-communicable stage means the stage beginning upon an individual's earliest opportunity for exposure to an infectious agent and ending upon the individual entering or re-entering the communicable stage of the disease, or if the individual does not enter the communicable stage, the latest date at which the individual could reasonably be expected to have the potential to enter or re-enter the communicable stage. What does that tell you, my dear friends?
What that says is that anybody, anytime, for any reasons, can be swept into one of these bizarre, absurd, insane, illogical garbage bin categorizations, and then if this applies only to non-US citizens, any foreigner who meets any of these criteria can be forcibly detained and treated, including vaccination. But if it does in fact pertain to more people than just non-citizens, anybody can be swept up and involuntarily assumed to have made an agreement which does not require their assent, and then treated in whatever way is suitable or good or desirable to the CDC. And there is nothing here that says that the treatment needs to be good for you. In fact, let's say that you are susceptible to X, Y, or Z component of whatever treatment is offered to you. And let's say that that treatment is given to you and it makes you sick or it makes you dead. Oh, well, the purpose of these regulations was not to assure your health anyway. Larry, Catherine, Ralph, do I see this correctly?
I would agree with you, and that's why I brought this into the conversation, because I believe it's a dragnet. Can I offer one more thing out of the proposed ruling?
Of
Which would
course.
even gild the lily further or put more topping on the cake. When apprehended and taken into custody, the person will be forced to be treated medically, including vaccinations. And if you refuse, the fines range from $100,000 to $500,000, depending upon circumstances, which of course I encourage everyone to read the entire rule to know the circumstances. But here's something else. Additionally, the person will be charged for the treatment, including room and board costs. And then if or when you are released, there will be two types of release. One is a conditional release. The other is an electronic or internet-based monitoring. Now, folks, this talks to me like we're talking, pardon the expression, FEMA camps.
Sounds FEMA-ish to me. Febrile, FEMA, extermination, tyranny, I don't know. They all seem to me to be in the same mix here. What do you guys think?
Larry, one question I had for you was, can any of these rules be lawful? I mean, it's
Well, Dave, Ralph, let me explain this. In 1946, America was being confronted with all these agencies that had been given rulemaking authority by Congress. And some of these regulations would implement the law, but other parts of the regulation would only simply interpret the law. Now, in 1946, Congress came out with the Administrative Procedures Act. It requires, what we're going through right now with this regulation, or with this set of regulations. Now an agency, when it's getting ready to come out with a new regulation, must submit it to the public for comment. And usually most of these regulations are going to be seen by industry groups. The industry groups have, companies and employees that kind of follow this stuff along, and so when something new comes out, they keep abreast of it. But there must be, the Federal Register is the daily newspaper of the federal government. So an agency has to publish, when it's going to propose a rule, it's got to publish it and make it available for comment. Now, a comment period is going to be set forth in the, the regulations, anywhere from 30 days, 60 days, 90 days, sometimes longer. And when an agency says it's available for public comment, and you're aware of it, if you find some objection to the set of regulations, people that are concerned should make a comment. I'll give you an example. When we were fighting the know your customer regulations and the national ID, this would be back in the late 90s, we started commenting on these regulations. And I remember specifically the time when we were dealing with one of those regulations, I don't remember which one, the comments got up to more than 200,000, and the agency withdrew them. So there's a reason why people need to at least sit down, and when a set of regulations is being proposed for comment, they need to sit down and read it. And if you have some complaint about it, you ought to at least write a letter and object to it and raise all your concerns. We got 200,000 people to object, and the reason I know that's the case, I was trying a case in Cheyenne, and I was going over at lunch, and right on the front page of the Cheyenne paper was, the story about how 200,000 people had objected to the regulations and the agency had withdrawn them. Well, we have right now this set of regulations. It must be subjected to criticism by those that are concerned about it. Then the agency's going to have to deal with it. And after they deal with it, they'll come out with a final set of regulations that have got to be published in the Federal Register. And after it's published in the Federal Register, it'll ultimately make it into the Code of Federal Regulations. Now, even if you have a regulation that's been adopted, there is still the opportunity to, complain about it later on. But at that stage, when you're complaining about it, it's going to involve litigation. And, basically regulations that can be subject to attack, you can come along and say there is no statutory foundation for the regulation. I'll give you an example of that. One of the agencies came out here, in the last couple of years and wanted to attempt to regulate, I think, nicotine, in cigarettes. That issue went up through the courts, and the court said, no, this is beyond the scope of the legislation, therefore the regulation, is not supported by statutes. So you have those types of arguments that can be made in litigation, but, if you're going to try to battle this here, make the comments, object to it. If you were a party that objected to it and the regulation gets enacted anyway, then you can file a lawsuit in court to challenge, hey, this regulation's bad for these reasons that I objected to. That's one way. Or to later on, when that set of regulations is going to be implemented against somebody, there needs to be a team ready to, come in and engage in litigation to show the reach and scope of the regulations.
Excuse me if I may interject for a second. When I read that proposed rule, and I could be wrong, Larry and Ralph, you are the attorneys, I sort of got the feeling that there was absolutely no way that anybody could do anything about this. You had no recourse at law.
Well, I must say that when I read the same document, it seemed to me that the entire point of this was that 100% of the power rests in the CDC's hands under the proposed regulations, and nothing like informed consent or any kind of redress was
I agree with you, Rima.
made available or was hinted at. Now, there may be an underpinning in law that no regulation or law can take away, but most people wouldn't know about it if that does exist.
If you're a member of the public and you're sitting down and reading these regulations, it appears right now during the course of this conversation that, even some of the people that are on this program, I need to simply tell, that this is my understanding, this is a proposed set of regulations.
Right.
Of course, they don't come out and map out what I just said about what you can do about regulations. That's kind of a given. That's the legal background for all regulations.
Okay.
But they do tell you, since these regulations are being proposed, they say, okay, if you got a comment, send, here's the address and send it to us. And so, a set of regulations, and for some of this environmental stuff, there were battles for years and years and years before they got the regulations in effect. And so the same thing can be done here, but it's going to take, it's going to take like what we did when we were battling Know Your Customers and National ID. You need a group of people. You got to form an opposition group. And the people that climb on board with the opposition group that have a unity of interest with it, they need to be given something that they can do rather than something they can't.
Indeed,
and that means.
Go ahead.
Well, I was just going to let me finish this comment. If something like y'all's your group could say, hey, here are some suggested objections. Post it on your website. This is what we did. We read through the proposal. We came up with a number of objections. We gave the people that were following that issue something that they could do rather than something they couldn't.
Exactly.
Well, they could easily read our suggested objections, and all they had to do was copy it, stick it on their letterhead. This is from me. Print it out, sign it, and send it in.
Well,
let's make it even easier. We actually have a web form to do that. And that web form is at tinyurl.com/informed consent protection. It's a form that automatically sends those messages for people. And yes, we've proven over and over again, Larry, that pushback works. And of course, it is a requirement of the Administrative Procedures Act. The agency simply can't proclaim a regulation. First, they have to propose it. Then they have, as you know, then they have to allow for public comments. And then they finalize the regulation, responding to comments. Now, sometimes they don't respond to the most important comments, but as Larry points out, since we filed a formal objection, we could be a plaintiff in attacking the regulation if it is approved. Back in 2007, we had 500,000 people flood the FDA with objections to their so-called CAM guidance, which would have created a new regulatory category without bothering to ask Congress. And they never finalized that regulation. It was never finalized. So, yes.
And the guy who wrote it commented, actually it was 688,000 comments through our action item, which crashed the FDA website, which made me very happy. And the guy who wrote the regulation commented in response to all of these negative evaluations of his work. Well, after all, I'm not Darth Vader. Well,
Right.
yes, actually, he was trying to be Darth Vader, but not the good Darth Vader either. So I have a question to ask you, Larry, because one of the most interesting and provocative discussions that I've ever had with anybody on the Dr. Rima Truth Reports was with you when you were espousing the concept that the FDA has no jurisdiction in the United States except for its jurisdiction over foreign. I'm sorry. Go ahead, please.
Ports of entry.
Yes.
This gets back around to, let me explain to you some of the provisions of the Administrative Procedures Act. The Administrative Procedures Act requires, if an agency is going to come out with a quote rule, and a rule is, like what we're dealing with now in reference to these CDC regulations. That's the typical rule or regulation. However, there are other things that are also rules. And the Administrative Procedures Act simply says, an agency's got to publish as a rule a statement of its organization and the channeling of its functions. Now, I have sat down and I have tested many federal agencies to see how many comply with this requirement. and too many do not publish a statement of their organization and staffing. Now, there's one possibility that, that could be a mistake. I disagree with the position that it's a, quote, mistake, because I see too many other agencies also publishing their structure in their regulations. Like, for example, at one time in the past, the IRS, published its organization and staffing. However, when the BATF was created and delegated responsibilities for, that subject matter, alcohol, tobacco, and firearms, suddenly, after the IRS had been deliberately publishing its structure for a long time, suddenly it just remarkably vanished. So the IRS knows, and Treasury Department knows the requirement to do this. Now, I'll give you another example. Here in Alabama, our Department of Revenue, for a time, we have a similar provision in our Administrative Procedures Act requiring the agency to publish. You got to know who's who at the zoo. I mean, I could trace back to the late 1800s. How the agencies understood it was for their own benefit for them to publish. If you've got this specific problem, you go see this guy right here at this address. It's a practical matter in order for an agency to operate. If you didn't say, tell the public who's who at the zoo, where to carry a problem and have somebody address it, then there would be utter chaos in the agency. And that's a practical requirement that appears in the Administrative Procedures Act. A lot of agencies comply, but then when they do comply, it's really weird. Like the FAA, they don't give you office locations; they will give you coordinates. Longitude and latitude. That's very very suspicious. It's longitude and latitudes for their field offices. But, the central office and the field office of an organization has got to be published in the Federal Register. Now, with that in mind, I just simply make this observation, that the FDA and all of its agencies, they are lax in complying with that provision of the Administrative Procedures Act. Now, to me, that says, well, since your structure isn't published, there's several things at play here. And one of the things that could be at play here is, they just made a mistake, which I doubt. The Administrative Procedures Act says, if an agency doesn't publish something and it's required to have been published, the public cannot be penalized for, not knowing about something that should have been published but was not. Now, going a step further, to me, there's a lot of international agencies. A lot of the federal agencies are really international in nature. I'll give you this example. I was up and working in Annapolis, back in the early, 90s, and I was driving back from Annapolis to a hotel I had elsewhere, and I was riding down the highway, and I listened to a radio program on a Sunday afternoon, and, in my position, I knew that at that point in time I knew that the DEA was really an organization, the Drug Enforcement Administration, really has laws that it really implements that are, find their origins in treaties. And so I'm riding down the highway listening to this radio program, and lo and behold, this guy that was the head of the DEA at the time, he's the guest on this, federally sponsored radio show, and that's the first thing that he has to say. The DEA is really, in essence, an international organization. Why is it an international organization? Well, Uncle Sam goes out and enters into all these treaties with other countries. We have environmental treaties. We have fishing conventions. We have wildlife conventions. We have, treaties out we have a multitude of treaties. Well, when we enter into treaties, I have seen, as just as a student of the law, I have seen, this event happen. As soon as we get a treaty, like the Genocide Treaty, as soon as we got the Genocide Treaty, one of the first things Congress comes along and passes legislation to implement the Genocide Treaty. And what it did is it made new crimes that it inserted in Title 18, which is the United States Criminal Code. Well, you have the same thing that, you can get on the internet for the Federal Aviation Administration, for the FCC. when you get back into taking a look at how radio and telegraphs were first controlled by Uncle Sam, it arises from treaties. Well, we have the same thing here with the environment. We have with communicable diseases. A lot of stuff that comes out of the UN. We have these international agreements. Uncle Sam comes along and implements them. So let's suppose, and another thing you need consideration, when Congress comes along and implements a treaty, then wouldn't you agree with me in this respect, that if Congress is implementing a treaty, then only those that are subject to the treaty would also be subject to the federal legislation. Ralph,
Well,
does that
right.
strike?
That's
Yeah.
very interesting. Of
But
course,
can I
and
bring
isn't there a famous case, folks, that in which the Supreme Court said that Congress could not control the flight of some birds in the U.S., but then a few years later,
That whole, I've got it over on my website. I've got a treaty explanation. If people want to go to my website, I've got a lot of jurisdiction there. I have a memo on treaties. The memo is really just an introduction to the topic. But you can find my website just by simply doing a web search, Beecraft Briefs, BECRAFT, Beecraft Briefs, like law briefs. And when you get over to my website, look for kind of at the top of the page, there's a link there for treaties. And, the historical development of, control over migratory birds is all based on treaties. And, in one situation, involving one judge, a judge held that when somebody was bagged, from charged criminally for shooting birds in Arkansas, he said, "Hey, Congress doesn't have any constitutional authority to control the hunting inside of a state." Well, then once we got a Canadian treaty dealing with hunting migratory birds, and then Congress came along and implemented it, another criminal case was started in Arkansas, and that defendant went before the same judge that had previously held, this is unconstitutional. Well, that defendant made the same blooming argument, and this time Judge Schreiber came along and said, whoops, now that we got the treaty, we do have the constitutional authority. But, it's far broader than what the purpose of this program is. I just see as a student of the law, too much of federal law, I can make an argument about guns. Don't get me started down that road. But, I just see too many federal agencies are really agencies been established to deal with laws, enforce laws that really boil down to, this redeeming principle. This is a redeeming principle that I see. The sovereignty, power, and jurisdiction of the United States is primarily external to this country, and I just see too many federal agencies really only having, that kind of an external look, outside the United States, and I think the CDC is one of those agencies.
Folks, can I introduce another dynamic, though?
Sure.
please.
In this proposed regulation that we're talking about, the CDC is going back and, in my opinion, going after the power grabs that have been given to them by something called presidential executive orders. And numerous of those PEOs are mentioned, and it's very interesting. They go back to 1983 with President Ronald Reagan, two of George W. Bush's in 2003 and 2005, Barack Obama in 2014. We've got another one from Obama in 2011. We've got a Clinton in 1993, and another one from Obama in 2011. So how does that dynamic apply to what Larry just spoke about? Because from my understanding of the presidential executive orders, they're sort of like one-man rule and nobody can challenge them. So how come in this...
Can I reply to that?
Pardon?
Can I reply to that?
Please.
Okay.
Go ahead.
Let's start off with a real important case. Harry Truman's in office. It's about 1951, 52. the unions are on strike. Gee, Korea's heating up. We can't have a strike that's going to affect the war machine. That's what obviously went through Truman's mind. So instead of having the strike come off from the steel workers, he went out and seized the steel mills. And that case, commonly called the steel seizure cases, went all the way up to the United States Supreme Court. And to simply state the results of that decision in the steel seizure cases, Youngstown Sheet and Tube against Sawyer, the Supreme Court said, the president just doesn't have the inherent authority to seize. He's got to have statutory authority. And of course, in this situation, if the president had some authority to, quote, seize the steel mills, that would give the opportunity to the steel company owners, to say, hey, here we got some legislation that we contend is unconstitutional. A lot of people in our movement, to me, give too much credence to executive orders. And I deal with executive orders when I'm studying a field of law that is being administered by government agencies. The President of the United States doesn't have inherent authority on his own. Too often when you take a look at, now let me back up. There's a lot of people that are going to sit there and talk about President Kennedy's and, and even some later one, the executive orders that say, I'm going to, in the event of emergency, I'm going to steal everything. Well, that executive order, it doesn't have any statutory foundation. To sit there and say, oh, the president can, just because he sees it in print, doesn't mean he can do it. And, I find a lot of the times people in the movement are not thinking in those terms, of what you're seeing in print, and connecting it to, some constitutional authority, to some statutory authority. And there's a lot of holes when you try to do that. And it's those holes that you need to see in order to develop a defense. But I would say in reference to yeah, absolutely. But I would say in reference to Catherine's observation, she's obviously, hey, I've only spent probably 5 or 10 minutes looking at those regulations. I didn't say anything about executive orders, but Catherine has. Well, this is without having to taken a look at those executive orders, I would suppose, I could be wrong, but, this is what my experience shows to me. I would say that some of those executive orders were probably dealing with some law that did, in fact, give the president authority to do something, and those executive orders have delegated that authority to, say, like the CDC. But you really can't just because you see executive orders. It's been my experience that a lot of people have some erroneous impressions about executive orders. When you're thinking in terms of executive orders, just hey, they're almost like, to me, a non-published regulation, So the president says he's going to do something. Big deal. Our defense is, we need to understand that the president of the United States doesn't have any inherent authority, to do whatever he wants to do. And, the Supreme Court said that in the steel seizure cases. He's got to have statutory authority. And, you got to go back to the statutory authority and then follow it forward. And then when you see, what the president does, you could see, it becomes a lot clearer what he is doing. But, the mere fact that you run across in a set of regulations a reference to president's executive orders, I think they're overblown in too many people's minds.
That's where, in my opinion, pardon me, Larry, that's where, in my opinion, I said, and in the article that I had written, the CDC is overreaching and going beyond their scope and going beyond their scope of agency,
authority, right?
etc.
Let's call it ultra vires, beyond their power.
Right, absolutely correct, Ralph. That's exactly what it is. But anytime we're dealing with a federal agency or a state agency, just any government entity, if you're going to build defenses, you got to really sit down and take a look at what's going on, and that can require extensive research. But then again, you don't have to engage in a lot of extensive research because all of the federal laws from day one, Volume 1 of the United States Statutes at Large, all the way up to the present. I'm not doing this year, but years ago I strung all the pages of the statutes at law together, made them word searchable, and posted them on the internet. So if you don't have access to federal laws, 15 years ago I made them available.
You did that?
Yeah.
Wow. Well, I think we all owe you a huge debt of thanks, and we want you to do it this year.
Here, here. Right now, folks, it is a little bit after 7, one halfway through the Dr. Rima Truth Reports. Remember, the website is Dr. Rima, DRRIMA, truthreports.com. When you go there, you'll see the blog. There are important entries in that blog. First of all, Dr. Rima has been reporting on General Bert's health. We've been continuing to publish messages from Japan, from Murata-san, the conscience of Fukushima, who continues to tell us that unless the 2020 Olympics are reorganized and out of the danger zone, the athletes will be at risk. So it's important for you to go there. There's another important website too, and that's opensourcetruth.com. You'll see it right there on the top of our screen for the live stream. Open Source Truth is an independent information aggregator that focuses in on health and health freedom issues. Important source of information. Dr. Rima, do you want to tell people a little bit about some of our product situations? I think
I
that the
do.
nano silver is an important one. And then we'll go back to our guests and continue this extraordinary discussion.
When I practice medicine, I look for the underlying core event, biochemical, psychological, neurological, energetic, mitochondrial, that causes the problem. And then I find that other problems that may seem to be not related are all indeed related to this central core situation. When you correct that, obviously you're correcting the causal event and the causal level, and everything gets better that's related to it. Now, in line with that way of thinking, and that, by the way, is very non-allopathic, very non-allopathic. But in looking for health tools that assist people in managing their own health and in taking control of their own health, I look always for things, for tools, for products that put health in people's hands and deal with the core event that makes something go wrong. And if it doesn't do that, then I'm not interested in it as a product. For example, nano silver 10 parts per million supports the immune system in such a way that viruses that have been tested can't penetrate the cell. And if they can't penetrate the cell, they can't replicate, and therefore there's no disease. Bacteria, the bad bacteria are wiped out, and the good bacteria are left alone. So you have an immune support that functions as if it were intelligent, as if these molecules were intelligent, and they do exactly what needs to be done, making nano silver 10 parts per million an extraordinary health aid. We have a Dr. Rima recommends nano silver 10 parts per million because it took me 16 years to find what I believe to be the very best nano silver in the world. And so the whole issue of infection is dealt with at the causal level by dealing with the organisms and with the immune system in a positive way that is totally non-toxic. Similarly, inflammation is a huge issue, we now know, in diseases ranging from autism to zoster. And if you want to deal with inflammation, then do what Mother Nature does. You introduce CBD, CBD, cannabidiol, which is made both by the hemp plant, and of course it's the non-psychoactive, non-get-you-high part, and by the body. And when you don't have enough CBD on board, but you add more, you tend to be able to correct that basic inflammatory issue, and the things that come from it go away because you've taken care of the causal level. And all of the products on our website, which is www.nsfmarketplace.com. NSF stands for Natural Solutions Foundation, unsurprisingly. All of the products there are chosen for you to use safely and effectively to put your own health in your own hands and deal with problems at the causal level, including something that you don't swallow and you don't put on your skin and you don't take internally in any way. And that is a card, a wallet card that says, I refuse all vaccines. I am asserting my right of informed consent. It's called the Advanced Vaccine Directive. And so dealing with the right, protecting and preserving the right to not be vaccinated forestalls all of the problems that you would have if you were vaccinated. And for those of our listeners who are with us in countries other than the US, this right of informed consent and the right to refuse treatment is in fact valid in all 126 signatory countries of the Geneva Convention. So what I'm telling you is you have tools and information and power to take your health into your own hand with just a few items, and that's available at www.nsfmarketplace.com. Thank you. I think this is something you need to examine, and you need to ask yourself how you can make your health better and put it more firmly in your hands rather than anybody else's.
Excuse
Indeed,
me.
Dr. Rima. And to conclude this little section of our program and bring our guests back on, I'd like to remind people that one way of asserting your informed consent right is to do so as Dr. Rima did with General Burt by writing it on the consent forms or by carrying with you an advanced medical directive card or two. There
And
are
I,
people.
I have
Yeah,
with me in my wallet General Burt's Advanced Medical Directive card and
right.
mine.
You
I
know,
wrote this on the forms, all vaccines refused, expecting to have to pull out my card. And what happened was people said, "Oh, okay,"
because they
and
know it's
they
the law. And people
exactly.
regularly carry I am a diabetic cards. I know some Jehovah Witnesses who carry cards that say I refuse all transfusions. And of course, you can obtain your advanced vaccine directive card from Natural Solutions Foundation. Go to the main website, drrimatruthreports.com. There's a way to get it right there on the main page, or go to one of our little tiny URLs at tinyurl.com/AVD card, AVD, Advanced Vaccine Directive. Dr. Rima, let's bring our guests back and let's
Well,
continue this
yes,
discussion.
Catherine was about to say something, and in our enthusiasm, we didn't let her. Go ahead, Catherine.
I'm sorry, and I apologize.
No,
I
go
would
ahead.
like to take us further down the rabbit hole.
Go
Can I
ahead.
do that?
Okay.
Sure. Let
I
us
have.
let us remind wait. Let us remind those listeners who have just joined the Dr. Rima Truth Reports for the second hour that our guests are Catherine Frompovich and Larry B. Kraft. Go ahead, Catherine.
Okay, United States Code Title 42, the Public Health and Welfare. And I have a 3-page printout here when I was doing my research into this mammoth thing that I think may put a different spin on things, if I may be so brash as to introduce this. Chapter 6A, Public Health Service, General Powers and Duties, Part G, Quarantine and Inspection, Section 264, Regulations to Control Communicable Diseases, Apprehension, Detention, or Conditional Release of Individuals, application of regulations to persons entering from foreign countries, blah, 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 blah. It goes on. But the thing that I want to specifically point out, and not to question or doubt what Larry or Ralph, who are attorneys, have to say, but I see specifically here in Section 264B, Apprehension, Detention, blah, 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 that it says regulations prescribed under this section shall not provide for the apprehension, detention, or conditional release of individuals except for the purpose of preventing the introduction, transmission, or spread of such communicable diseases as may be specified from time to time in executive orders of the President upon the recommendation of the Secretary in consultation with the Surgeon General. Interesting?
Indeed, indeed. But of
Well,
course,
are
that's
you
just saying they're authorizing themselves. That's all it's
That's
doing.
right. That's right. But let me go a little further then, please, if I may, with regard to this. See, I personally have a big problem with the presidential executive orders. If you or anybody who is listening to this show want to check out where I write for activistpost.com. And if you Google my name, Activist Post, and put in presidential executive orders, you will see how many articles I have written about that, where I contend they are totally unconstitutional and they are one-man power grabs. That is my personal bias and opinion. Having said that, I have in front of me the Executive Order 12452 that was issued in 1983 by President Reagan, which was rescinded and changed in with the Executive Order 13295 in 2005 by Bush, and it goes on to define things a little differently, which is very interesting. So this is why I brought this into the discussion, because it is my opinion, unless we address this in our comments or somehow as some sort of a talking point with regard to how the CDC is trying to get their self-empowerment, we may be missing something rather important. Pardon me.
Now, I would very much like to have your response to what Catherine's just brought up, Larry.
Well, I've looked at executive orders for years. And, one of the first executive orders to come out was George Washington's executive order. Didn't have any statutory authority. I just want there to be Thanksgiving. And, ever since then, presidents have come out with their annual proclamation of Thanksgiving. There's no statutory foundation for that. You have to, when you look at an executive order, the ones that will be statutorily authorized are going to be making some kind, the presidents will come along and make proclamations about this is National Green Apple Week, and there's a lot of those, he's thanking some industry. Those are just window dressing and they mean nothing. The ones that are important are the ones that, have a direct connection to legislation. Typically, when you look at an executive order, and, there's plenty of executive orders on the White House website, like, for example, FDR. There were some changes in the monetary system back during 32, 33, 34, that era.
Yeah,
Congress came along
remember?
and enacted laws. Congress would come along and enact laws. And then the statute would give him some authority to make a proclamation. And so, in that type of a circumstance, the president will go out and investigate, whatever he's directed to do by legislation. And then he will make a proclamation. Proclamations, they're very common. Let's say that some country, let's pick China. China's engaged in some kind of unfair trade with the United States. Well, the president, there's statutes to say, well, the president, will look into this matter, and if he sees that there's some unfair advantage arising from foreign commerce, he can make a declaration, and when he makes that declaration, that certain tariffs that are already set forth in the law will apply to goods from, say, like China. You have to take a look at the proclamation, and too many proclamations, sit there and say, pursuant to this provision of the law, I'm doing thus and such.
Would the treaties that you talked about come into play there too?
Well, yeah. I can see how if you get let's say a whaling convention. I maintain the whole authority of the U.S. Fish and Wildlife Service arises from that type of stuff. Where does fish in the U.S. Fish and Wildlife Service come from? It comes from the fishing treaties. Where does control over wildlife, by Uncle Sam, where does that come from? It comes from treaties. And in fact, the courts will sit there and tell you, the Endangered Species Act, one of many laws, federal laws dealing with wildlife, it's really implementing a treaty. People may not be aware of all this, and I am taking the opportunity to educate a lot of people about, the fact that we do have a lot of treaties around the world. The United States is signatory to a lot of treaties. There's a lot of federal laws that implement treaties, and there's a lot of agencies that just have that responsibility, like the FAA and FCC and FTC and the U.S. Fish and Wildlife Service, and also maintain the FDA. But getting back to executive orders, when you're reading along in a set of regulations, you're not really going to understand it. And this is the reason why you have to devote some time to it. Just the mere fact that you can, like Catherine has done, she's sitting there and reading these set of new regulations as references to presidential executive orders. You still have to go a step further and go actually look at those executive orders. And then when you see the executive order, if it's really going to mean something, it's going to say, I hereby, pursuant to this, 21 U.S.C. Section 544, I do thus and such. And, a lot of times you can see, when you're looking at that, you can see overreaching. And when you see, president making something that's overreaching, therein's going to be your defense when the problem comes up. So, you got to make that connection between, a federal law, and then you got to follow it through, and there's a lot of following through. If the president's going to be involved because the president's going to be given some type of authority pursuant to the statute, to do certain things. Quite often the president's going to be, he's the chief executive officer. Too often, federal legislation is going to either tell the president to do something, or it's going to delegate something to an agency that the Congress has created and tell them to do something.
Larry,
so, you can't, go ahead, Catherine.
May I ask a question, please?
Sure.
In the 13295 that I was talking about of 2005, in section 3, it says, the functions of the president under section 362 and 364A of the Public Service Act, paren 42 U.S.C. 265 and 267A, are assigned to the secretary. They were talking about Secretary of Health and Human Services.
Right. Yeah.
So how does that work now, please?
Well, that's just simply a delegation of authority. Too often, federal legislation will come up and say, and this gets back around to the Administrative Procedures Act requirement that, the agency publish the channeling of its functions. Years ago, Congress would create agencies, and then once it created the agencies, it'd pass a law that say, okay, this party of this agency is going to do thus and such. Well, when you set up by legislation, the structures and functions of a government agency, quite often that's going to be cumbersome and inefficient. So in the late 30s, Congress comes along and passes a law allowing the president to reorganize agencies. And there's been a lot of reorganization since that time. And in fact, we've gotten Title V, I think it's Title V of the United States Code, Section 901, 902, that deals with reorganization plans. About 1948 or 1949, Congress comes along and passes just the general law authorizing the president to reorganize executive agencies. One of the first things that the president did when the Reorganization Acts came out in 1950, he started reorganizing the Treasury Office and the Treasury Department. And the way that they did that is, he came out with a reorganization plan, and he took all the statutory authority from the Treasury Department. He took it away from everybody. Well, that's allowed by the reorganization plans. And then he, delegated all the authority he took away to everybody else. He delegated that to the Secretary of the Treasury. Oh, but we know the Secretary of the Treasury doesn't go out and do everything. He doesn't collect returns, assess taxes, engage in criminal investigations. Well, he has this giant agency. The IRS alone has 100,000 people or thereabouts employed. But so the way you can accomplish that is you come out with these delegation orders. So if a party is delegated statutory authority, as too often the president is, and too often the president is incapable of doing everything, he delegates that to different parties, in agencies. And too often, what the president's done is, if he has statutory authority, boom, he delegates that to a certain party, and then that party can make sub-delegations. And all of that is required to be visible in the Federal Register. You sit down and you look for the published delegation orders. And that is an incredibly time-consuming endeavor. You have to use the tape.
That,
oh yeah, but getting back to your question, I'm just exposing you, Catherine, to I would like to see you when you're running across executive orders actually look at them. Some of them are meaningless.
Well, now,
the president's authority to proclaim Thanksgiving. I mean, that has no effect.
That's not an executive order. That's a proclamation. That's a totally
different
thing.
But there are executive orders just of the same nature.
Why would very ominous sounding provisions be promulgated in executive orders? And if you read them, they're very scary. Why would they be promulgated if they have no legislative or statutory authority to make them meaningful? I don't get that.
Good question, Dr. Rima. That's my question, too.
Okay, now, can you restate it again, because I had problems hearing your voice, Dr. Rima?
Okay.
Oh, hold on one second. No, I can do it, Catherine. I said, okay. When you read the executive orders that are promulgated, as Catherine has done, as I have done, as many people have done, but we're not lawyers, this is true. When you read them, they sound very, very intrusive, threatening, abusive. They say the president can, for example, commandeer anything in the country in times of national need, and then it goes on and on and on and on about what can be commandeered. And you read that and you say, my God, that is terrifying. And then as I listen to you, I learn that unless it has legislative or statutory authority, that has no meaning. So my question is, why would the government spend time and effort putting out things that have no meaning, that are ominous and intrusive? What's the game?
Well, I can't tell you what the game is. There's probably several different games. I could simply tell you this. I think that you and I are on, you're referencing those executive orders issued by President Kennedy that in the time of emergency, they'll seize this, that, and the other. Is that what you said just a minute ago? Were you referring to those JFK executive orders to seize everything?
I am, but I'm also referring, and Catherine may be able to cite the specific items. I'm also referring to some by Bush and a fair number by Obama that say essentially the same thing in one way or another. And it could be in time of communicable disease. It could be in time of national emergency. It could be in time of unspecified disaster. Catherine, can you pull any out of
Yes,
your
I have them here. I have them
archive?
exactly here. Here they are. The 4 presidential executive orders dealing with communicable diseases are these. PEO 12452, dated December 22, 1983, President Ronald Reagan. PEO 13295, dated April 4, 2003, President George W. Bush. PEO 13375, dated August 1, 2005, President George W. Bush. PEO 13674, July 31, 2014, President Barack Obama. Those are the ones that are specific, but within the body of this proposed rule that CDC is overreaching with, they have cited several others as their bases for empowerment. If you'd like to have those, I can give you those numbers too.
Well, I can't make any comment about the substance of those executive orders beyond this. The courts require that this is black letter law, so to speak, from the courts. A public official must have the authority to act. That authority comes from statutes. If it doesn't come from statute, but statutes can also be, misconstrued by government agencies. They can, they can be overbroad. You can still attack the statute. The reach and scope of a statute. Including here in this instance, what we're talking about, interstate and domestic commerce. But without looking at what the executive order says about its statutory authority, and without having looked at that statutory authority, it's kind of almost difficult to discuss those executive orders.
But may I guess I'm playing devil's advocate here because
Sure.
I think this is the bugaboo here. I have looked at so many and read so many of President Obama's PEOs that in each one he specifically has cited, by the power given to me by the Constitution, I can do this. Now, there is no power given to him by the Constitution.
No, absolutely not. And that's the reason why I brought up the steel seizure cases.
Well, you know what?
I'm just, people need to know about this. Catherine, you're probably going through what a lot of people in this movement do. They read these executive orders and, wow, the president without understanding the legal context of it. The president
I think I do understand the legal context of it because I'm saying they're basically BS. He has no constitutional right to do this.
Absolutely, and the authority for that is the steel seizure cases. He can't just come out and say, well, I'm gonna seize all these people that are coming into this country. He's not doing that, but if he just can't say, I'm going to go out and seize a whole bunch of people. I'm going to go out and shoot a whole bunch of people. I'm going to go out and poison a whole bunch of people. He doesn't have that inherent authority. There is no inherent authority on the part of the president. The only constitutional authority that he has is the authority to execute the laws of Congress.
That's right, but he can
appoint judges, but
the current president that we have has overstepped that and has gone into lawmaking, just like the CDC now is trying to go into lawmaking, in my opinion. I'm sorry.
Well, that's absolutely true, and what that does when they're overly broad and without statutory authority, until people, this is the problem I see with the movement. People want to talk about, they're shocked, man, this is overbroad. Well, I look at the, fields of inquiry, concerns of the people. Say, well, what are the defenses? And you need to be looking at the defenses. And a lot of people accept, wow, the president can, see this. The president can seize my car. Well, the defenses are no, he can't. And there's just too much of, I encounter too often, people are not thinking in terms of defenses or finding holes in what they're doing.
And I think maybe, if you'll pardon my saying this, and I'd like to hear the other people on this string, their idea, I think we should start to talk about some of the things that people should put into the comments to make that impression so that it is an elephant gun to the CDC's regulations.
Right.
So you are the attorney.
Ralph?
Let's start with you.
Well, right now you're kind of catching me. If it's directed toward me, you're kind of catching me flat-footed because I haven't been looking at this. You know, I thought that was directed more toward Ralph because he's the one that made the suggestion. Hey, we've already got comments that you can download and throw in. You know, they're posted on our website. Am I correct, Ralph?
Absolutely. We have it actually. One of the things the foundation raises money to do is to pay a monthly fee to have the right to do just that. There's an organization called Democracy in Action, which was a nonprofit itself at one time, that has 1,000 NGOs, including us as members, and we all chip in, and they maintain a list of all the elected officials. They have a system that all you have to do is put your zip code in, and the message goes to your legislators, state and federal, your governor, president, and of course, in this case, FDA and CDC. And that's at tinyurl.com/informed consent protection. Now, that's one way of approaching it. We also filed a formal comment in the CDC's own comment system because, of course, again, that Administrative Procedures Act tells us how we have to proceed. And I think, Larry, what I took from one of your comments earlier is maybe if you want to challenge one of these regulations, you must file a comment at this stage. This is part of the exhausting your administrative remedies. And it is true, folks, that the government agents do respond to the comments. For example, back in 2000, when the FDA published its structure and function claims notice rule for dietary supplements, that rule is a page and a half of bureaucratic gobbledygook, but it's preceded by about 90 pages, some 300 and something paragraphs of commentary where the FDA takes a comment from some member of the public, and almost all of these comments were in the form of whether a certain phrase should be or should not be allowed to be used in connection with dietary supplements, and FDA responded to the comment. And they do this regularly and typically when they provide this sort of regulation process. If they didn't do it, it would not even be a lawful regulation. It would not even be a regulation that was adopted in accordance with the Administrative Procedures Act. So it's important for us to assert our informed consent or lack thereof. We need to assert it in the administrative process. We need to assert it when we go into a hospital and sign consent forms. The whole point of this regulation, and when you look at the actual regulation and you look to where they talk about consent, the whole structure of the regulation is to override informed consent. And that's why it is
Actually
so
deny
dangerous. Yeah, right, exactly.
Deny it.
Go ahead, Catherine.
It's actually a denial of informed consent as opposed to overriding.
It's more than a denial. It cancels it. It says
Yes.
we're going to make an agreement with the individual, but the individual's consent or agreement to agree is irrelevant.
That's
so
correct.
The agreement is we agree with ourselves, and what you say doesn't matter. Now, I would like to point out that we've been talking about some very, very important underpinnings of the reality of this event, this attempt to take power in a particular way. But what we haven't emphasized is that you can do something about it. Ralph mentioned it, but I want to circle back to it. Whenever we, in our righteous wrath and indignation, rise up and say the same thing to one of these federal agencies or state agencies, if we are sufficient in our clarity and in our numbers are critically important here, then each and every time the agency, the person, the regulation is pushed back. But if you say, well, let somebody else do it, or I'll take the action, but I'm not going to spend 10 minutes or 20 minutes sharing it on my social media with the contacts that I have who might be interested in protecting their freedom, their children, their lives, their um, immune systems, and so on, then we will not succeed. So it depends on you. It depends on you remembering that there is a dirty little secret to globalist destruction of our freedoms and our rights and our awareness that we have rights, which is necessary before you can exercise a right. And that is, they want you to feel isolated. They want you to feel impotent. They want you to feel as if it's all too big for little old you. You are not isolated. You are not impotent. And it is by no means too big and too complex for little old you. So we urge you with all the strength that we can muster to do what Larry said, to take action. And you do that by going to tinyurl.com/informed consent protection. It can't get any simpler than that. You go there, you read it, you click one button, you fill in your identifying data, which is, of course, kept private, and then you click submit. Your state legislators, your governor, your federal legislators, your head of HHS, Health and Human Services, the president, the vice president, all of them get your email when you click one time. I call it riding the freedom mouse. Now,
I like that.
I would like the commentary of both of our guests, Catherine Frompovich and Larry B. Kraft, on the idea that we have the power to enact pushback against these well-organized, physically gummy person who, we have the ability to really push back. And I'd like your commentary on whether you believe that this is true, and we can do it now.
Larry,
Catherine,
would you like
ladies
to go ahead?
first.
Okay, thank you. I'll just give you some personal experience. In the 1980s, Representative Claude Pepper introduced 3 horrendous bills that were going to do away with holistic health care. I was in private practice as a consulting natural nutritionist. I had clients all over the country. Long story short, this was before the internet. I became involved, sent out as much information as I could on the networks that were available at that time, and guess what? Representative Claude Pepper took back those 3 bills, and we won.
Yes.
Because I got, you ready for this? I got a phone call from his legislative aide she wanted me to know that Representative Pepper wanted me to know he was never going to introduce those bills again because he didn't want to have to deal with the likes of me again.
All
Wow.
right.
All
That's
right.
pushback.
We knew we loved you for a reason, Catherine.
Listen, I'm an old dog in this fight, ladies and gentlemen. It can
We
be
don't
done.
have any old dogs on this fight.
No, none at all. Larry, what's your perspective? You're a fighter too, and you've
Well,
go ahead.
this is a battle. I've been battling my whole professional career against, the state, the power of the government. Our strength, they have a strength. They got guns and ammo. They got tanks. They got airplanes. When you go into battle, you use your strong weapons. Our strong weapons are our numbers. We have a lot of people.
Exactly.
They hate the mice that roar.
Right. And I learned long ago, if you want to rally the troops, get them excited, and then give them something they can do rather than something they can't. There's a lot of people, we don't need a bunch of people going out here and engaging in pro se lawsuits, that they're going to destroy some things. But we do have a whole lot of people that can simply copy something, post it on the internet, print it out, sign it, and stick it in the mail. And in reference to battling this particular set of regulations, I've experienced myself. Just two guys years ago were able to start the movement to ultimately result in 200,000 objections being made to a set of regulations that made the front page. The only place I saw it was in Cheyenne, Wyoming. But, it was just two of us that did that. Here we've got four people on this call, and I know that Ralph and Dr. Rima are associated with a whole bunch of people who are activists. Catherine is a walking one-man army. And if we can't get, a bunch of people, I think we need to set a goal here. Let's have, 100,000 objections to this hit the FDA or the CDC, here with before the comment period ends.
Well,
I
I would disagree with you, Larry, strongly. I would say
Okay.
let's go for a minimum of 500,000.
I was
This
thinking
is
that too.
this is a really, really important regulation to them. This is something that the public-private partnerships and the agencies and the Gates Foundation and the UN and the Global Health Security Initiative have been salivating to get. This is really important to them, and therefore they are coming at this with a lot of energy from a lot of different directions in this particular gambit. Therefore, I think we have to bring a large number of people against it, saying in one way or another, and in the action item that I told you about at tinyurl.com/informed consent protection. There, you will be able to personalize the letter that you send if you like. That's entirely fine. And a huge array of letters will go out. But if we have a limited number of people or a minimal number of people, they will discard it. 500,000 they'll listen to. More than that, oh yes, their ears will perk up and they will have to drop back.
But there has been a sort of inflation, I'm sorry, folks, in the power of pushback. Back in 2007, 500,000 emails stopped the FDA. In 2009, 3.5 million emails derailed the swine flu vaccine panic. In 2010, 11, 5 million emails kept our dietary supplements, at least in theory, safe from the enhanced FDA authority.
They're going after them again now.
Oh, of course they are. Always,
yeah.
And in 2013, down in Chile, where Dr. Rima and General Burt were living, a couple of million emails, which is a much, much larger percentage of the Chilean population, stopped the so-called Ley Monsanto, the Monsanto law that would have given that company and its likes control over the seed market in Chile. So it seems that it may take millions of people to get attention, but that's exactly what we need to do. We need to find a way, and we need your help, you folks out there listening in and who will be listening to this archive. We need your help in making this message go viral. And what is the message? The message is, don't you dare.
October 14th.
Right.
It has to be done by October 14th.
Right. We have
Look,
less than
the
a month.
CIA is helping us. The CIA is helping us. The CIA and DARPA and like agencies have spent a huge amount of money, an inconceivable amount of money and time and effort, creating a system that links us all so that they can surveil us all. Well, we understand that's what social media is, but it also works in the opposite direction. It links us all so that we can communicate. I'm sure that's not what they would really like it used for, but we can do that. You have friends and contacts and connections on social media who have friends and contacts and connection on social media, and we need to be the source of information and change and motivation to get the social media provided by DARPA and the CIA and all of those nefarious bad guy agencies to control us. We need to use it to decontrol ourselves and render ourselves able, fit, and legally permitted to determine our own health care and our own course of health through informed consent by protecting it at www.informedconsentprotection.
That's
It's
actually,
not a
Dr. Rima,
small thing.
that's actually tinyurl.com/,
Oh, I'm
informed
so sorry.
consent protection. tinyurl.com/, informed consent protection. Well, the whole issue is, can we expose what the CDC is actually planning? They've written their regulation fairly carefully. They talk about agreements. They talk about all sorts of nice things. And then they, as Catherine pointed out, they treat in the same basket. Maybe it's a deplorable basket. I don't know. They treat self-limiting diseases like measles the same as Ebola. Ebola was never in the United States, even. It's just quite extraordinary, and it's an
Yeah, but hey, but
indication
Ralph,
of the desperation of the CDC to find some excuse, any excuse, to override the right to informed consent, our universal right to informed consent. What General Byrd has said is, and I quote, the defining issue of the 21st century. Larry, go ahead.
hey, Ralph, you say that Ebola is not a problem. Hey, may I suggest also that Ebola started not in the United States but in Africa. And Dr. Rima will tell you it was created by probably some American manufacturers, but that's what CDC should be looking at. That's its real function. It's got to be looking at those diseases in other parts of the world that can be brought here to the United States. That's its job. Its job is not domestic.
Very interesting.
Wow. Very good point.
So
Very good point.
it is acting ultra vires whenever it acts against us in our own country. But its job
Well,
is
this set of
to
regulations
protect us.
might also.
Yeah.
I'd like to see how they explain some of this stuff. I haven't done it, but I'd like to look at the underlying statutory authority that supports what they claim is this program that they're implementing. Chances are there's going to be a whole lot of overreach in this set of regulations. And, if you can find an overreach, then you got a way to combat this legally, because the courts will sit there and say, hey, look, here's the statute and here's what you said, and gee, the regulation's overbroad or the regulation without any statutory foundation.
Now,
And y'all are telling.
if I write to the CDC and I say, could you please show me the statutory authority upon which this proposed regulation rests? Do they have any obligation to answer me?
No, there's only the law does not require, constitutionally, a government agency isn't required to answer any question. You have a right to petition the government, but the government isn't required, even though we have the petition clauses in the First Amendment. No agency is required to answer. They're only required to answer, if a statute requires them to. And since October the 14th is so close around the corner, I would suggest one or two things. Go look at the regulations. Typically, at the front of the regulations, they're going to tell you what their statutory foundation is. But if it's not there, contact your congressman and say, hey, look, I need an immediate answer, and see if he can help you.
Oh.
But I doubt if the agency is going to respond to you before Christmas.
That's very interesting. Ralph and Catherine, you probably have copies available to you right now. Is there any indication at the beginning of the regulation what the statutory authority might be?
No, I didn't print it out because
No,
the thing is so
I
doggone
am.
long. I would have to use Arima paper.
Yeah.
Well, but you go back, the chances are you're looking at what was published in the Federal Register as the rule. So
Yeah.
you go to page, 49607, where it starts. But in the first couple of pages, I presume you probably have downloaded the PDF of what was published in the Federal Register. We'll go back to the very beginning of the document.
I can give you the Federal Register number. I can give you the Federal Register number if you want it.
Well, hey, Catherine, email it to me, and then I'll after the show's over with, I'll take a look at it.
Excellent.
Okay,
Very
all
good. The official summary, as I read earlier, says this is a notice of proposed rulemaking, and it is amending its domestic, interstate, and foreign quarantine regulations. So it's amending existing regulations to, quote, best protect the public health of the United States.
Interesting.
Yep.
Well, we
Dr.
have
Rima, we
had
have 4 minutes on the program, so please bring us on down.
Well, this has been a very interesting program. I think I've gotten a lot out of it. I'm glad to meet Catherine.
Likewise, I think between amongst the four of us, we've got more brains than maybe the whole CDC. Or am I saying that?
Well, we've all been appearing on each other's radio programs over the years, and Dr. Rima and I now want to start to bring together some of these wonderful individuals, like both of you, who we've learned so much from in the past, and sort of remix the mix and see what happens. And you've really taken us down some interesting rabbit holes tonight. And this we appreciate.
Indeed. And
but Ralph, this is what I have learned about Catherine. She has a million irons in the fire.
Oh yeah.
She's even battling smart meters, and I'm wondering when she's going to reach the point of burnout.
No. That's a dirty word, and it's not in my lexicon.
Well, now. A couple of years ago, you said in a private email, I'm done. I've reached a certain age. I want to retire. I want to enjoy myself. I'm done. And I said, ha.
Yeah, you're about the 100th person to remind me of that. I must be like one of those old race horses or milk horses. When they hear the bell, they got to keep running.
And I said, in 6 months, you will be back. And it was about 3.
Yeah, and I've written 3 books since then, too.
Yes.
Did you see my last book that I sent to Ralph? Eat to Beat Disease, Foods and Medicinal Qualities?
I saw that it was there, but I have not. I have been just a tad occupied, Catherine, with the impending but then deflected death of General Burt.
Oh, that's good news to hear.
Thank you.
I mean,
thank you.
Hey, Dr. Rima, I didn't hear you when you were talking about what you did for helping Dr. Burt get better. I think there's some missing ingredients here, and that he's just plain old tough.
He is tough. This man has been, he lost 44 pounds. He is deconditioned. He's extremely weak. He's extremely vulnerable. And the physical therapy folks came in today and said, we want you to sit on the edge of the bed. And then they mouthed to me, he won't be able to do it. And General Burt said, okay. And he sat on the edge of the bed supporting himself. And the physical therapist said, you can't do that. And General Burt looked at her and said, who made that rule?
He's a tough bird. That's what's going to help him out, too.
Absolutely. This has been a wonderful show. Thank you all. And folks, you have been listening to the Dr. Rima Truth Reports with Dr. Rima Ilebo, MD, Ralph Fusatola, JD, our 2 amazing guests, Catherine Frompovich and Larry B. Kraft. And if you're listening on the archive, welcome, and please go to www.drrimatruthreports.com and put your name in the email slot so that we can send you our free newsletter, and and keep you updated on this and other fascinating and vital areas wherein your health and your health freedom lie. Thank you so much for being with us.